Good afternoon, everyone, and welcome to the NCSL Standing Committee on Health and Human Services conference call on the Child Care and Development Block Grant Reauthorization. For all of you who are joining us today via the webinar format, I just want to ask you, once again, you saw it typed in the chat box, that we would very much appreciate it if you could please type in your state so that we may know who is on the line and who is participating in the call. This will help facilitate some of the things that our speaker will address today. This is an operator-assisted call and will be recorded for posting on the web so others may access the information at another time. There will be an opportunity for questions at the end of the presentation, and we plan to rotate questions between those that have dialed in and those listed in the chat box. In November of 2014, President Obama signed the bipartisan legislation reauthorizing the CCDBG program, which was the first comprehensive reauthorization for the program in nearly 20 years. The legislation altered the goals of the program and created 6 new goals that strengthened requirements related to health and safety, licensing enforcement, and quality of care. Today we're going to discuss the final rule implementing the CCDBG Act and updating the Child Care and Development Fund regulations that were published on September 23rd, 2016. Inspection requirements for licensed and exempt providers had to be in place by this month, November of 2016. But there are other statutory deadlines that include background check requirements that must be in place by September 30th of 2017 and posting the results of monitoring on the Consumer Education website by November 19th, 2017. And we are so very pleased to welcome as our guest speaker, Rachel Schumacher, who is the Director for the Office of Child Care within the Administration for Children and Families at the Department of Health and Human Services. Welcome, Rachel.
Thank you so much, and I'm very happy to be here. Hello, everyone on the call. Very excited to share with you some information that will hopefully make your work easier going forward. As Rachel Morgan said, the Child Care and Development Block Grant, it's been around for a while, been around since the mid-90s, but it really hasn't been overhauled, since its first creation. And what happened in 2014 on a bipartisan basis was really an amazing update looking at all the research on child development that's happened since the 90s and really looking at what was going on in terms of families being able to work their way out of poverty and really trying to think about what could we do to make this program work a little bit better for both children and their parents and really have it be more of a 2-generation program than it had been actually functioning as. And so I really have had the great privilege of having the opportunity to work with the Office of Child Care over the last couple of years. I started right after this piece of legislation was passed and signed into law, and we were able to get our regulations out in September. So so we were joking around beforehand about I'm always very anxious and happy to talk to this group, and one of the reasons is that actually my first job out of school was working in the Massachusetts State House for a state legislator, and I was there for 3 years, and I learned the basis of what I know about child care policy from the state level there, and then I went on to work in Ohio, not in the legislature, but in a local level on early childhood policy and doing a lot of sort of visits with legislators and things like that. And I really get how important your role is and how many decisions you make that really affect the children and families in your communities. And sometimes that gets overlooked. Everyone's always thinking about it all at the federal level, and especially with the block grant, we know that's not true. We know how important it is, everything you do in the state level. And particularly with this piece of legislation and the regulations, there's a lot of things that need to be changed in your state legislatures, most likely, and you may have been hearing about that already. So we'll talk about that a little bit. The Child Care and Development Block Grant is $5.7 billion to states and territories and tribes, and we've actually been able to raise that a little bit over the last set of years. It's gone up by $400 million since the passage of the law. But we know that there's a lot more that you need, and this administration has definitely requested a lot of additional funding, and we haven't always gotten the levels that we've wanted, but we really believe that this is an incredible opportunity, and Congress really saw this as an opportunity to fine-tune the rules and law, and then hopefully have states to be very successful in implementation, and that would really change what child care looked like around the country and make it a program that they would continue to want to invest in. So we absolutely get that this is not an overnight process, and that when we put out the rule, we put in it that the goal for full implementation of anything that was in the rule that hadn't been clear from statute before would need to be implemented not for another 2 years. So we're looking at 9/30/2018. That will be when the Office of Child Care starts going from a full-on technical assistance stance to more of a monitoring stance. But even then, we really see ourselves as partnering with the states, and we want states to be successful in everything that they're doing here. It's just too important for children and families for that not to be the case. So we've been really trying to think about that in everything we do. That said, we also recognize that a lot of states have already told us they needed more time, and the Congress recognized that might be the case and put in the opportunity for states to ask for extensions, and 25 states did. Some of you are on this call, and some of you may be planning on asking for additional waivers on the background checks because those didn't have to come in yet, and those aren't due until next year. So we have an opportunity to be really a little flexible with our state partners and help you, as long as you're making progress, that we can give you a little bit more time, and we hope that we've been able to do that. And before I move on to the next slide, I'll just say 19 of the states of the 25 that asked for extensions on particular provisions said that one of the reasons was that they needed to make changes in their state regulations and laws to do so. They had to work with their legislature, and they needed more time. And so a lot of the time that they wanted was partially because the rule wasn't out. They knew what was in the law, and the law is pretty clear, but there were little specifics that they were waiting to get clarification on. And now that the rule is out, they feel that they have that, and they're going to be probably coming to you, if they haven't already done so, to say, and these are our state administrators, the Child Care Block Grant state administrators, they're probably got a list of the things that need to be changed in order for them to move forward. And so this is a great time for us to talk to you and to clear up any questions you have either today, or if there are questions I can't answer, we'll get back to you, because you're going to be so essential to partner with the child care administrators to help them move forward and be successful in implementation. All right, that was a huge amount of information for one slide. Let's move on. So what I'm going to talk to you today is about 4 major topical areas that I think we already kind of heard a little bit from Rachel, but it's health and safety, consumer choices and access to information, providing equal access to stable, high-quality child care for low-income children, which is obviously what the subsidy part of the program does, and enhance the quality of child care in the early childhood workforce. And that's because this program not only provides care for low-income families that the states you are using to help do that, but there's also a set-aside for quality that is actually available to improve the quality of care for all children in your state, not just for children receiving the subsidy. That's something a lot of people don't know. Let's move on to the next slide. One thing that the ACF folks had an opportunity to do is, you may be aware that the Head Start program also has brand new requirements and brand new rule that was released about a month before ours. And so in the process, we were able to really look at each other's drafts and try to make sure that there was alignment where appropriate. So I know that's something we've tried to do. And so a couple of areas that we just want to mention to you that we really tried to align were things around the new health and safety standards that are required under the CCDBG law, including training, referring both to child care law and the Head Start performance regs, and our rule referred back to a document called Caring for Our Children Basics, which is based on experts weighing in and advice on what some of the key basic kind of health and safety rules need to be in order to make sure children have a basic level of safety. And both of our two sets of standards look back at that and refer to it. So that's an area of alignment. And they also, and where we had background check requirements put in the law by Congress, Head Start is also going to apply those to their programs, which in some ways would happen anyway because it applies to all licensed programs, but this just was another way in which we really tried to make sure that we weren't making it difficult for states and communities that are putting working with child care and Head Start programs both, or having child care subsidies in Head Start programs and vice versa. We want the same level of quality to the extent possible for children, no matter where they are. And so we really tried to figure out how to do some areas of alignment there. Next slide. Okay, and you can move on to the, once we look at the pretty one, then we can move on to the ones full of words, which unfortunately is the way most of my slides look often. The health and safety requirements, just what's in there. So before this law was passed, there were provisions in the CCDBG law that said that every state needed to have licensing standards, but they could exempt some programs, and that was about all it really said. Congress decided they wanted to have a basic floor and push more towards licensure for more programs and the way way their language reads. So one of the things they did is ask states, and your state did this in their state plan, to describe in their state plan why licensing exemptions do not endanger children. They also have specific health and safety requirements. States need to make specific health and safety requirements related to specified topics. And these are really basic topics that you would want people to have, like first aid, CPR, SIDS prevention, giving children medicine, hygiene, emergency preparedness and response, really basic things. So states need to have rules for how providers meet those requirements and then also train them initially within, and we said in the rule, within the first 3 months of them coming on board, not necessarily before they start, and also have ongoing training mechanisms on these basic, on health and safety for all CCDF providers. And the rule also said, and exactly what the law said, so no different, that monitoring had to occur for providers that were receiving the CCDBG dollar at least annually. So this would include even the license-exempt providers, but the law and the rule both allow states to exclude relative providers. So a provider who's taking care of only their own blood relative children doesn't need, the state has the flexibility to say, we're not applying it to that particular type of provider. All right, next slide. Monitoring. As I already said, and Rachel said in the introduction, November 2016, which is here, CCDBG requires that licensed providers have a pre-licensure and annual unannounced visits, and license-exempt providers have an annual visit. And the law also says that licensing inspectors need to have qualifications, that the state has to decide what those should be, and also that the ratio of inspectors that the state has, so this means like the number of providers that a particular inspector is required to work with, is not so overwhelming that they can't meet the requirement that they go there annually. So that's also something states were asked to set and speak to in their plans that were already submitted. And I should back up and say, just in case you're not aware of this plan I keep mentioning, so states have to apply for their funding for the Child Care and Development Block Grant, and it's called CCDF, the Child Care and Development Fund. That's the name of the rules that was given in a previous administration. So the CCDF plan, that is something that states submit every 2 years, except Congress changed it. Now they made it every 3 years. The next plan that after the law passed was due, it was actually due almost like a year and some months ago. We gave an extension to states so they didn't have to submit them until this summer, and then we have already gone through and given conditional approval to states of their plans. And it was conditional because so many of the provisions that were in the statute could not yet be were not yet fully implemented in states. And so they have all conditional approval. That's sort of a backup. I should have had a slide about that in the beginning. Anyway, so when I keep saying CCDF plans, those are plans that your states already submitted and received conditional approval for, and they have implementation plan sections in them where there were 26 new requirements in the statute that were put into the plan. States wrote to where they were in implementing those, and very often they had to say, we're not going to meet the deadline and we're going to apply for a waiver and we need more time. So we, as I said, had 25 states who did apply for and receive an extension of some amount of time, up to 1 year from September 30 of this year. Okay, next slide. Criminal background checks. So criminal background checks are very comprehensive. We have the most comprehensive requirements now that have been passed by Congress as of yet. Ours are even stronger than what Congress put into the ACA. The comprehensive background checks for child care staff is for all licensed, regulated, and registered providers and all providers eligible to deliver CCDF-funded services, including those licensed, exempt, and relative caregivers. But states, again, can exempt relative caregivers. And so this is much far-reaching than the health and safety trainings and things like that, which could be limited by a state only to those who are receiving CCDF dollars or who want to be eligible to take a voucher. In this case, this is much wider. You'll see at the bottom it says that the Secretary may grant an extension of up to 1 year as long as the state is demonstrating good faith efforts to comply. This doesn't kick in until September 2017. And we have been very busy at the Office of Child Care collecting states' concerns and comments about how to implement these. The next slide gives you more detail on what is being required. Can we go to the next slide? There we go. Okay, components of the criminal background check include these different pieces. This is all new, much more high level and required. Many states have some of this, but not all of it. And one of the things that states didn't have before in many cases was that Congress required a search of the following registries in the state where the staff member resided, and each state where the staff member resided during the past 5 years. So you need this fingerprint check from the FBI. You need a search of the National Crime Information Center's National Sex Offender Registry. After guidance is released is something we put in our preamble for the rule when it came out, because we heard from states that this was really, really difficult to implement. They don't always have access. They don't have access to this. This is something that they have to partner with the criminal justice system to get access to, and we need guidance from the FBI to really be able to make that happen. So we clarified it in the rule that that is something we recognize. They also, as I said, have to do these searches of data from other states, and that's the other thing that we've been hearing is going to be really challenging for states to do. My computer just went black. Let me try to pull that back up. Luckily, luckily, you're not looking at my screen. Let me just pull it back up. There we go. All right, so the next slide is moving on to consumer choices and access to information that supports child development. So one of the new things in the revised law is the purpose of encouraging parents to engage in their child's development and to have good consumer education was always something that was in the law. But now it's also about engaging families. And so how are we going to do that? So if you move on to the next slide, Congress really looked at what's the best way to get information out there. And one of the things that was never in the law before, as you can imagine, since the original one was in the 90s, was making information available on a consumer education website. Many states have them, but they didn't necessarily have all the information that a parent might need to be able to find out, how to pick good quality care or what their health and safety record was. We had stories of staffers who actually sat and went looking and played with the state's websites and looked at, what we had funded nationally through the Child Care Aware of America, and they said to us, hey, we have some ideas. There's some things we want to fix. So the law requires states to make information available electronically, including all the processes for licensing and monitoring, the quality of providers, monitoring and inspection results. So those annual monitoring reports need to go online, and that they need to go online within a year of the deadline of the monitoring actually starting. So that's why that's next November. And the number of deaths, serious injuries, and instances of substantiated child abuse that occurred in child care settings each year. And the rule just adds to this only by saying that these components be combined in a consumer-friendly and easily accessible website and aligns with federal and state website requirements. So if a state has a quality rating and improvement system, the quality of providers piece of information could fit into that. The other thing that states are needing to do is start to think about how they would describe the quality of the care being accessed through the child care subsidy, because Congress became very concerned, hey, we're putting all this money into all these private providers, and it's going all over the country, and are we getting positive brain development and child development because of it? And they wanted to have more ideas of what the quality looked like. So we are also moving toward requiring that all the children who, and this is a separate process, but we put it in our form, so states will have to report on the children, what kind of care children get through the subsidy program, and to the best extent possible, we'll be starting to need to report the quality level. Okay. Let's look at information for parents, providers, and the public. The law requires states to provide information on a lot of things, and I feel like if I list everything, the consumer education section is very, very long, and I don't want to make it so we don't have enough time for back and forth. But here's a list of some of the things that are in there, and these are things that need to be provided. The big thing is to parents, providers, and the public. So the website is a great way to do it, but it also has to be provided directly to parents who are coming into the program. And states are also looking for ways, need to look for ways to make sure providers are informed about a range of things around subsidy, research on child development, and other things, so that they can be partners with parents in helping them access the services they need and answer questions about their child's development, and all these things that we know really support parents so that they can do their most important job, which is to be parents. Let's go on to the next section, which is about providing equal access to stable, high-quality childcare for low-income children. Equal access is a provision that was in the original rule and law, and it continues to be in this law and rule, which is that participating in the program is supposed to help low-income children move toward equal access to high-quality care. And that's actually a purpose now of the law, and it hadn't been before. The biggest thing that states are talking about and doing, although we know that about 40 states have already told us that they're at 12-month eligibility, so they have made a lot of these changes, but we do have a set of states that ask for extension to implement this provision, is lengthening eligibility. So the law and rule establish minimum 12-month eligibility periods, regardless of temporary changes in the parent's status as working or intending job, training, or education. as long as the family income doesn't go over the federal maximum, which is 85% of state median income. And this really came about because a lot of the data that has been looked at over the last couple decades since this program started showed that children and families were churning in and out of the program. 3 months, anywhere from an average of 3 months to 7 months in most states. And so what's been changing over the last set of years is folks looking at that's not good for child development. And it's really hard for parents to keep a job if they keep losing their eligibility, or to find a new job if they have a temporary change, or they're in school and they're on a spring break, or they're on a summer break and they lose their child care. So Congress made this change. If you go to the next page, next slide, Congress also recognized that states might want to have a little flexibility in implementing this. So the law and the rule both give states the option to end assistance prior to the end of that 12-month period if there's a loss of work or cessation in education and training. But even in those cases, at least 3 months, I don't know why I said 6, 3 months of continued assistance is required for a family to get themselves back into eligibility status so that they can find a job or enter into another training program that will help them. Okay, so next slide. The Congress also put in a provision called graduated phase-out. And this was in response to data showing that families were reaching the end of their eligibility period or reaching the end, getting a small little tiny raise, and all of a sudden they became ineligible for the program. They lost their subsidy. The cost of care was well higher than they could afford, and then they had to quit their job and get back on the program. And that's not something Congress wanted to see continuing to happen. So they said there needed to be a graduated phase-out for families who, at redetermination, exceed their initial lead agency, the state's set lead agency income threshold, as long as their income is still not above the federal 85% of SMI. So this is an area where we had a lot of comments on the policy proposed in the NPRM, and we adjusted it. So we had one version of the rule that came out. We got lots of comments, and then we made changes, a lot of changes. So the final version of this does say that that lead agencies continue to have the authority to establish their initial income eligibility threshold at or below the 85% of SMI. So most states aren't at that level. That's about 250% of poverty. So states can still do that. It's just that when a family comes back in at the 12-month point, if they're below the 85% of SMI, the state needs now to set an exit threshold that can either be at 85% of SMI, or it could be at another level that the state determines based on looking at data on low-wage work raises and what it takes to give a family a reasonable shot at being able to continue to access child care once they leave the program. So the first version was, the one we proposed in the NPRM was all about a time limit. We walked that back. We got a lot of comments saying time is not the way to look at it. It's really more about whether the family is able to continue to be stable, even if they lose their child care subsidy. And so that's the way the rule is rewritten. For homeless provisions, the law requires a lot of things around homelessness. There's a lot of talk about the importance of prioritizing this population. And the new rule does actually make homeless children a priority. That flows really easily from what the law said. The law says that there needed to be grace periods, including for health and safety requirements, so that homeless children could start receiving the subsidy before they were maybe able to track down some of the paperwork they might need to qualify, recognizing that that's very difficult when you're homeless. States also need to provide training and technical assistance and outreach and coordination with other programs to be able to reach the homeless population and serve that population. sorry, I forgot to say next slide. Next slide. The next slide is around equal access. So there was a lot of discussion about the way provider payment rates can affect whether a family who's receiving subsidy actually has access to the full range of providers in a community. And states are required by the law to certify that payment rates are sufficient to ensure equal access for eligible children comparable to child care services provided to those who are not eligible, and also to provide a summary of facts used to determine that. If you go to the next slide, the Congress also gave states the ability to use a market rate survey, which they already were doing, or an alternative methodology to set rates. And that the Act requires that provider payment rates be based on one of those or both of those. It's up to the states to decide. And we actually have some tools available that have been available for several years on our website, our Training and Technical Assistance website, around cost estimation. To look at, instead of just looking at what the market cost is when you're in a low-income community and everyone's low income, the cost of care might be really low because that's what the market can bear. That might not be enough to attract people who have some training and education to actually care for young children, or staff might turn over really a lot because they don't have the ability to pay them very high salaries due to the fact that everyone's low income in the community. Parents really can't afford the cost of high quality care. And that's really true not just in low income communities, but all the way up, practically all the way up the chain of families. It's very expensive. So what this talks about is that you can use ways of looking at the cost of care, like a cost estimation model, in addition to or instead of using the market rate survey. The rule just specifies how that process works. So this is the details about it. You probably don't need to get into all of them, but just that there needs to be some consultation in the process, that we also need to, if you're doing an alternative methodology, ACF needs to just be aware ahead of time that that's happening, and that it's important to look at variations in cost by or market rate by location, category of provider, child age. Infant care is a lot more expensive than care for school-age children, etc. Okay, so let me move on to the next piece. Family co-payments. Okay, so the law had some provisions on co-payments, but the rule clarifies some of these things. So we prohibit lead agencies from increasing co-pays within the 12-month eligibility period. The law said that families, once they become eligible, should remain eligible and get the same set of services for 12 months, and that was interpreted to mean the same services at the same cost to the family, etc. So that's a change. We recommend a new benchmark of no more than 7% of a family's income being what the co-payment level is. Although we do in the rule talk about that co-pays should not be changed during the 12-month period, the state does have the flexibility to change the co-pay period during the graduated phase-out, because that's a period where families are gradually hopefully getting more of a raise and things like that, and so you would want to be able to adjust the co-payment over time so the family is ready to take on the cost of care. And we also put more flexibility in the rule to allow states to waive co-pays for families that meet criteria that the lead agency and the state decides. Before, that was limited only to families below poverty or with the Child and Protective Services. Okay, let's go to the next slide, just in the interest of time. I'm trying to get us time to talk. So the next thing is around, the law had several provisions around the importance of provider payments, saying that it was important for states to use generally acceptable practices in the payment of providers. And so the rule does interpret what that means based on comments that we had from Congress and from the field through the process. So this includes ensuring timely payment, delinking provider payments from occasional absences of the child when they're sick, and reflecting generally accepted payment practices, as I said before, and providing payment for any services in accordance with the payment agreement or authorization for services. So we had a couple of provisions in the rule where we try to explain what these things mean, and we give different options for states to come into compliance with what these things mean. Because as soon as people looked at the law, they said, well, what does timely payment mean, for example? And we tried to look at what states were doing. So, for example, we said you could either pay a provider prospectively, more like you would on a contract basis, or you could pay providers retrospectively within no more than 21 calendar days of the receipt of a complete invoice. So on all of that kind of stuff was based on what we talked to states about what they were doing, and it seemed to be within the realm of current practice, except for some outliers. All right, let's move ahead to the next section. Enhancing the quality of childcare in the early childhood workforce. So I'm sure many of you are aware that our workforce is often actually eligible for public benefits themselves. They make incredibly low wages, and they are doing incredibly important work. Congress was aware of this as well, and also that they really wanted to see the quality of care improve. So if you go to the next slide. The law gradually increases over a 5-year period the amount of the quality set aside that needs to go for quality investments. And the state gets a lot of flexibility in how that is invested, but the amount will have to go up to 9% by fiscal year 2020. There's also a new infant-toddler set-aside, recognizing that infant-toddler care and high-quality infant-toddler care is the most hard to find. Congress added a new 3% infant-toddler set-aside starting in this year, fiscal year 2017. Next slide. So you can see over time, this is what that would look like in terms of the proportion of the amount of funding that would need to go to these two purposes. Next slide. So I said Congress did put a little bit more language around what a quality activity should look like, but they also have an other. So there are 10 areas that Congress laid out for states to use their quality dollars for, and the 10th is other, as long as it's a measurable quality activity. So I'm sure many of you are thinking, yes, these are things that my state is using, is funding right now. Resource and referral, training and professional development, looking at quality rating systems. There's infant toddler again. So these are things that a lot of folks are already using their money for. So we don't expect that to be too hard for states to meet, and in their plans, they laid out what they were doing. Next slide. And then another area that Congress addressed in the law is the need to build a supply of high-quality care. So states were asked to describe strategies that they were using to increase supply for some key populations and underserved areas. So infants and toddlers, children with disabilities, and those who need care during non-traditional hours. The law also talked about prioritizing populations with high concentrations of poverty and unemployment and public-private partnerships to increase supply and quality of care. Most of these things, there's no particular new requirement that was put in the rule. There's just some additional information about and recommendations for what a state would want to do, like looking at data to decide where to invest the money, things like that. So there's not a lot of changes that were put in the rule there. For training and professional development, the law requires states to require pre-service orientation and training. We already talked about that a little bit with the health and safety slides much earlier. And to create a progression of professional development for CCDF providers, and that would go all the way and may include pursuit of post-secondary education, and to provide assurances that training and professional development will improve the quality, diversity, stability, and retention of the workforce. So in the rule, we pretty much just amplified what it was that was in the law. The pre-service and orientation training applies to all CCDF teachers, directors, and caregivers. That's one change, just to be clear, because the term provider sometimes makes people think the center itself. So we just wanted to make sure it was about the individuals. And we also talked about the importance of certain, like what a progression of professional development would look like, what a state framework would look like for professional development. So there's some language around that in the rule, but everything that was in there is based on information we had about what states were doing in their professional development activities around the country. Next slide. So we have a lot more information available and details available on our website, and we'll be having more as time goes on. We were able to, this came out as Rachel Morgan said, we were able to post this the 23rd, and then the following week we had the state administrators and teams from states coming into DC, and we were able to provide a pretty detailed training for them on the rule, which was wonderful, and everyone was really happy. We were able to get that all done in time so that they had that information to go be prepared for the legislative sessions so that they can come back and think about what type of information they want to prepare for you all, most likely. So with that, I will conclude and say again, next slide, thank you for everything you do for children and families. And Rachel, I'll turn it back over to you.
All right. Thank you so much, Rachel, for your presentation. We really do appreciate your time. Now we'll move into taking a few questions, and I'm going to let one of my colleagues describe how this is done so that we can get you in the queue, and then I will bring up a couple of important issues that we feel you might want to hear some answers to while you're doing that, and then we can go to your specific questions.
Thank you. If you would like to ask a question over the phone lines, please press *1 to be entered into the queue. The operator will then open the phone lines one by one based on your order in the queue for questions. If you're using audio through the computer, please go ahead and type your question into our chat box, which is located in the lower left-hand corner of the screen to submit your questions. When the operator opens your line, please state your name, what state you are from, and whether you're a legislator or legislative staff. I'll turn it back over to Rachel for some of those important questions.
Right. Well, given that Rachel Schumacher's already addressed, and I know that a few of you came on the line after she had talked about some of this concerning the implementation, and we've heard a few questions as to, with the change in administrations, how much of the rule may be moving forward, may not be moving forward. We would appreciate you readdressing that just a little bit, but also looking at and talking about your insights in terms of what some of the issues are that you're hearing from the states. And I know you've had lots of discussions and worked with the states on their plans. So you have a fairly broad knowledge of what challenges are out there amongst the states in terms of implementing all these new requirements. We'd like to hear what you might describe as the issues that state legislators may want to consider more as a priority than some others, given some of the implementation timeline and so forth. If you could please address those issues.
Okay, let me unpack that. So one thing that we just, and I think you could tell from how I presented this, the vast majority of what is in this rule was in statute. So that's why we were able to go forward with the child care plan that they all submitted already and we conditionally approved based on reasonable interpretation of the law. So most of these things are were very specifically outlined, and we see that states have been moving forward and implementing a lot of these things. So we've been really excited to partner with them and help them think about them going forward. That said, we do know that there are some states, it really depends on the state, right? So in one state that I do not see on the list, we know that they felt like almost everything needed legislative approval. They just couldn't move forward, and their legislation has also in that state needs to be really specific. So everything from requiring health and safety training for providers, monitoring inspections being required, and all of these background checks is a big area. All of these things required legislative action. So it really depends on the state, right? And each state and administrator at this point has, although they are turning over a lot, has done some analysis of, okay, I can do this, I cannot do that. So in many cases, because they saw that this was moving forward and in the law, they've moved forward on a lot of the things. The things that are sticky are the things that they think they need legislative action for, the things that haven't been done. One of the biggest things people have concerns about are the background checks, because they require cooperation across state lines, and they require cooperation between the child care agency and criminal justice, which is not something that they had ever had to do before. So, or some states have done it already, like Oklahoma's been doing it for a long time. Other states, hadn't. So we've been doing a lot of technical assistance to help them think about how to do that, and we've started a national background check center that is doing a pilot with states in Region 5, which is the Midwest region, Illinois, Michigan, Minnesota, those states, and Region 10, which is, I'm not sure you follow federal regions. I know that's internal speak. Region 10 is like Washington, Oregon, Idaho, those states, and Alaska. So we're trying to help them figure out how to solve that problem. So that's one of the things that we've heard from the very beginning.
Right.
Some of the other things that states are struggling with is just how do you implement the changes? And for that, it's more of a technical assistance answer. So we're going from 6-month to 12-month eligibility. How do I estimate what that looks like? How is that going to affect my caseload, my costs, my bottom line? We have a National Center on Subsidy Accountability and Innovation. This great center, we've had it for a while. We were just recently able to extend their contract. They're working, and they run, almost everyone who's there is a former state administrator from a state. So they're all people who've done this, and they're working really closely with states around the country to help them figure out how to estimate how to do these things. So those are some of the questions that we've been getting quite a lot of in those two areas. And I think the other one I didn't mention before, Rachel, is health and safety trainings, just getting the bulk of people trained and monitored. That's something that is partially a financial issue and partially just operationalizing it, just making sure that they have trainings available. We have online trainings that we have put online and have been online for a long time that have been funded through federal partnerships, the Department of Defense and other agencies that they can use if they want to.
Thank you. Operator, do we have a question on the call on the phone line?
No questions on the phone as of yet. There's 2 in the chat.
All right. We have a question from Connecticut. That's asking, a few of our statutes require the lead agency to, within available appropriations, to conduct background checks or set health and safety standards. The federal law now requires these regardless of available funding. Is that correct?
Yes, thank you for that question. The federal law doesn't have any phrase similar to what you're telling me Connecticut has. It just requires these things to take place. So I think your assessment is correct.
All right, and then we have a question that's coming from Missouri. Did the department consider ability of providers to address inspection issues before published online? Before being published online?
That is a really good question. I think what that question is about is what are the protections for providers around, like if there's an inspection report and they don't agree with it, what opportunities do they have to work with their state around that? And I'm feeling like that's a question I can't answer in detail, but I know we did address that because we did get a lot of comments about how does this work, and some states do have procedures. The states that already are publishing them have procedures in place to make sure that there's a reasonable way for a provider to appeal an assessment. The idea for monitoring reports would be that they would need to be through a typical, the legal process that you would typically use in your state for reports, and that providers have some protections. I'll have to get back to you on exactly what the language is, but I'm pretty sure we have something in the rule that specifies that.
Right, right. And we have another question. This is following up on the first question I asked you from Connecticut. Was federal money provided for increased costs related to background checks, et cetera?
So at the beginning of the call, I mentioned that $400 million more are going to the CCDBG block grant than was before the law was passed. This administration has requested significant increases in child care in the last couple of budgets. The Congress is currently still considering the budget, and as you're all very much aware, is overdue on finalizing it. And there, I don't have final information. No one does. Everything is sort of in flux right now since we're having a transition in powers going on after the election. So as soon as we have more information, our office shares it with our grantees. In the interim, what we do is just you're continuing to pay out based on a continuing resolution. So we're at the level that we were with that 400 plus, that million that came on from the level we were at when the bill first became law at this point.
Right. Operator, do we have any questions on the phone line?
No questions yet.
Great.
I see something here about what are the qualifications for inspectors set by the rule. We did not set qualifications in the rule. That's state job, and we didn't try to step on states on that. We just specified that they had to have appropriate training and qualifications based on the type of care that they're expecting. So family child care versus center-based care versus license-exempt care, and the age of children cared for and the kind of care they went to look at. So most places serve children birth to 5 or even birth to through school age, but those were important considerations because we know babies and toddlers, for example, have a different. You'd want a different environmental setting and kind of health and safety in an infant and toddler setting than you would for preschoolers or school agers, for that matter.
Well, if there are no more questions, I just want to thank Rachel for giving us all this time this afternoon and her presentation, which has been very helpful. I just want to urge everyone who may not have had their questions answered fully, or if you think of something else, to please let me know by contacting me via email or calling. And my email address is rachel.morgan@ncsl.org. And that's R-A-C-H-E-L is how I spell my first name. Or you can contact Rochelle, and her email address is rochelle.fenzel@ncsl.org. And she spells her first name R-O-C-H-E-L-L-E, Fenzel, F-I-N-Z-E-L. And just let us know if you have any further questions. And I'm going to let Rochelle make any closing additional remarks that she has.
Sure. Thank you, Rachel. Both Rachels, actually, Rachel Morgan and Rachel Schumacher. Really appreciate all of the information that you've shared with us, and certainly will be helpful as states move forward towards implementation as our members gear up for the legislative sessions. So I just want to remind everyone on the call that certainly NCSL is here to help you both in terms of understanding the federal, what's in the federal rules, as well as what's happening at the state level. And as both Rachel's mentioned, some states have already implemented some of these new requirements, so we are happy to help share some of those examples so you can see what other states are doing. We are available to come and either testify or present at any of your hearings or committee meetings, and certainly providing any other state-specific resources about how to implement the new requirements. So we are here to help you, and thank you all for participating. The slides will be available as well as the audio of the webinar, and we'll be sending that out to members. And we certainly hope to see some of you in DC in a couple of weeks for our Capitol Forum. We'll actually be continuing this conversation, and you'll have an opportunity to ask more questions of the federal representatives and also discussing other pressing issues. So we look forward to working with you, and have a great afternoon. Thank you so much.